What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to be taking a look back almost 11 months ago, a year ago. Michael Morrissey gave a statement on the Karen Reed prosecution. And if you don't know who Michael Morrissey is, he is the sitting district attorney in Norfolk County, which is where Karen Reed's trial is taking place. He is the leader of the attorneys prosecuting her. He is the one that picked Hank Brennan to be the special prosecutor for trial number 2. And he made a statement to the media. I had never seen it because it was prior to trial number 1, and I had never watched really anything that happened prior to trial number 1. But so many of you said you have to absolutely watch this statement that he made, and I am so glad I did because I've got a lot of thoughts. And before we actually get to the interview, we're going to read through specifically Massachusetts rule of professional conduct, Rule 3.6, which deals with trial publicity for lawyers involved in criminal cases and civil trials. We've read the ABA version. We've read some other states' version, but today we're going to focus in on Massachusetts and see if he did anything to violate the rules of professional responsibility. So make sure you guys hit that like button and let's get started. So it's important to note that lawyers are all bound by the rules of professional conduct, but there are obviously different burdens and different requirements and different rules for the people that are involved in a case, whether that's supervising, the attorney actually asking the questions, versus somebody like myself who may talk about a case like Karen Reed's case. And I think it's kind of cool because Massachusetts rule specifically differentiates that and says what the rules are for one and the rules are for the other. But to make sure we read the rule in its entirety and nobody can say I just read one paragraph or took something out of context, what we're going to do is we're going to read the whole rule first. Then we're going to watch the video of the interview. And during the interview, I'm going to pull back up the rule and talk about what paragraphs specifically go with what statements he's making, what's okay that he's saying, what's maybe not okay, and does he cross any lines that should be of grave concern in this case. So here we go. Rules of professional conduct, Rule 3.6, trial publicity. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So number 1, absolutely, without a doubt, Michael Morrissey is somebody who has participated or is participating in the investigation or litigation of this matter. So if it's going to be something that's disseminated and materially prejudicial, he cannot make an extrajudicial statement. There's no doubt in my mind this is an extrajudicial statement. There's no doubt in my mind that he knew or should have known this was going to be disseminated by public communication. The last part is the only thing in question. Will what he says have a substantial likelihood of materially prejudicing the matter? And because that's a little bit vague and it's legalese, this rule does a good job of explaining and giving us some specifics about exactly what that is. And we're going to get there. B, notwithstanding paragraph A, a lawyer may state. So even if you shouldn't make extrajudicial statements, there are some scenarios where you can make statements. Number 1, they may state the claim, offense, or defense involved, and, except when prohibited by law, the identity of the persons involved. 2, the information contained in the public record. Makes sense. 3, that an investigation of the matter is in progress. 4, the scheduling or result of any step in litigation, aka the trial date is here. That's also public. A request for assistance in obtaining evidence and information necessary thereto. If you have any information on this case, please let us know. We're still investigating. All that's okay. A warning of danger concerning the behavior of a person involved when there is a reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. If we remember, Luigi Mangione, when that investigation was going on, hey, we have somebody that's very dangerous and potentially armed running around New York, Pennsylvania, whatever. Be on the lookout. Let us know if you have any information. All of that's okay. In a criminal case, in addition to those paragraphs, you can say the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in the apprehension of that person, the fact, time, and place of the arrest, and the identity of the investigating and arresting officers or agencies and the length of the investigation. No problem. C, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So this is going to be a big one that we're focusing on. This is the one Baldoni and Blake Lively case that their lawyers are using. Hey, I had to come out and say something because the other side has said something materially prejudicial. I had to set the record straight, and it fits within this paragraph. Will that be the same argument for Morrissey? We're going to come back and look at this once we listen to his statement specifically. D, no lawyer associated in a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. E, this rule does not preclude a lawyer from replying to charges of misconduct publicly made against him or her from participating in the proceeding of a legislative, administrative, or other investigative body. Again, if there's some misconduct leveled against you, which maybe this is something that Morrissey would also argue he is making a statement for. Now, here's a comment. And this is basically to help us understand why the lawyers wrote this rule, why we have it, what it's here for, any additional information of any vagaries that may be in this rule. So this is where we're going to get some additional information. So let's read the comment together. Number 1, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. And we've seen that a lot in this case. People saying it's free speech. People may be getting arrested for something they claim is free speech. So they're going to deal a lot with this in this case. Preserving the right to a fair trial necessarily entails some curtailment of the information that may be disseminated about a party prior to trial, particularly where trial by jury is involved. So if you think complete inaccuracies are being thrown out there, maybe you do have a right to prevent something from happening to create a situation where it's not a fair trial. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. On the other hand, there are vital social interests served by the free dissemination of information about events having legal consequences and about legal proceedings themselves. And it's important that this be applied to both sides in this case. The public has a right to know about threats to its safety and measures aimed at assuring its security. And again, is that what he's doing here? Is he trying to protect the masses? Is he telling them about threats? It also has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. Furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. This is why it's important that we are allowed to and should be encouraged about discussing these cases. They are incredibly important to public policy, which means how it affects all of us in America, in Massachusetts and beyond. Number 2, special rules of confidentiality may validly govern proceedings in juvenile domestic relations and mental disability proceedings and perhaps other types of litigation. The rules set forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing an adjudicated proceeding. So this is the rule. We lawyers, if it's a case we are involved in, really should not be making public comments on them that could materially prejudice the proceedings. And if we do, there should be a reason or exception that it fits into. Recognizing that the public value of informed commentary is great, okay? They recognize that the public value of informed commentary is great. Talking about these cases is great. We should talk about these cases. And the likelihood of prejudice to a proceeding by the commentary of a lawyer not involved in the case is small. So let's talk about it. Let's discuss it. I'm a lawyer not involved in the case. There's lots of lawyers you guys watch on YouTube and in the media generally not involved in the case. Let's talk about it because it's important public policy questions and answers we can get from discussing these cases. And what I say is not going to prejudice a jury. It's small. Any effect it's going to have is going to be small, especially if a lawyer is talking about it the right way. Explaining the legalities, not telling you have to see things one way or you're stupid or you don't understand the law. If you don't see it the way me, a big bad lawyer, sees it, that's not the way to discuss it. So the prejudicial effect that a lawyer like myself should have should be small because I should be saying, look at all the evidence, balance it, weigh the evidence. Don't come in with preconceived notions. The defendant is presumed innocent. That's why this rule applies only to lawyers who are or have been involved in the investigation or litigation of a case and their associates. So while Morrissey might not be in court, he may not be asking the question, there's no question that this rule applies to him in this case. If he wanted to comment on one of my cases, this rule would not apply the same way to him. Comment 4. Paragraph B identifies specific matters about which a lawyer's statements would not ordinarily be considered to present a substantial likelihood of material prejudice and should not in any event be considered prohibited by the general prohibition of paragraph A. Paragraph B is not intended to be an exhaustive listing of the subjects upon which a lawyer may make a statement, but statements on other matters may be subject to paragraph A. Comment 5, and here's the big and important comment. There are, on the other hand, certain subjects that are more likely than not to have a materially prejudicial effect on a proceeding. So this is the people writing this rule. They're like, hey, something that is likely to have a materially prejudicial effect on proceedings, that's kind of vague. So let's spell out what is more likely than not. Not guaranteed, not every single time, not all or nothing, not always or never, but more likely than not. We're going to help you out, lawyers, and give you some specific examples of what usually will fit into something that you should know may materially prejudice a proceeding, particularly when they refer to a civil matter triable to a jury, a criminal matter, which we have here, or any other proceeding that could result in incarceration, which we have here. So what are some examples that are more likely than not to have a materially prejudicial effect? Number 1, the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness. Additionally, an identity of a witness or the expected testimony of a party or a witness. That's going to be an important one when we go through a statement. In a criminal case or proceeding that could result in incarceration, the possibility of plea of guilty to the offense, or the existence or contents of any confession, admission, or statement given by a defendant or suspect that the person's refusal or failure to make a statement. The performance or results of any examination or test, that's going to be important, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. Number 4, any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration. Number 5, information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, or that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Or number 6, the fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. Spoiler alert, he does not say anything about the defendant's presumption of innocence or that they are innocent until proven guilty. Comment 6. Another relevant factor in determining prejudice is the nature of the proceeding involved. Criminal trials will be the most sensitive to extrajudicial speech. So everything we're reading in this question applies to Morrissey, applies to this case, and in fact, this is the most sensitive of all cases for any extrajudicial statement. That applies to Karen Reed and her team. There's a little bit of a difference, though. Civil trials may be less sensitive. Non-jury hearings and arbitration proceedings may be less effective. The rule will still place limitations on prejudicial comments in these cases, but the likelihood of prejudice may be different depending on the type of proceeding. Finally, the extrajudicial statements that might otherwise raise a question under this rule may be permissible when they are made in response to statements made publicly by another party, another party's lawyer, or third persons, where a reasonable lawyer would believe a public response is required in order to avoid prejudice to the lawyer's client. Okay? You can respond to protect your client because that's what you do as a lawyer. That's going to be important here. When prejudicial statements have been made publicly by others, responsive statements may have the salutary effect on lessening any resulting adverse impact on the adjudicated proceeding. Such responsive statements should be limited to contain only such information as is necessary to mitigate undue prejudice created by the statements made by others. So again, this is going to be something that Morrissey would argue protects a lot of his statements here. In the statements permitted by paragraph E, a lawyer must safeguard confidential information relating to the representation of a client. See this rule for additional duties of prosecutors in connection with extrajudicial statements of a criminal proceeding. All right, so now let's go to the interview with that at the top of our mind, and we're going to reference it as we listen here. As the seasons change, so do your skin's needs. Shifts in the weather can leave your skin feeling irritated, tight, and dry, especially if you have sensitive skin or skin conditions. Enter today's sponsor, OneSkin. Founded by 4 PhD-level researchers, OneSkin is the only company with the OS01 peptide, the first ingredient scientifically proven to reduce the dysfunctional senescent cells that build up as you age and make you more sensitive to those seasonal symptoms like tight, dry skin. Founded and led by an all-woman team of skin longevity scientists, OneSkin is redefining the aging process with their proprietary OS01 peptide, the first ingredient proven to help skin look, feel, and behave like its younger self. So get 15% off with code LYK at oneskin.co. That's 15% off at oneskin.co with code LYK. And after your purchase, they'll ask you where you heard about them. So please support our show and tell them that we sent you. Invest in the health and longevity of your skin with OneSkin. Your future self will thank you.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney.
So right off the bat, sorry for stopping it so quickly, but the fact that this is the first time he's ever had to make a statement like this in a dozen years as Norfolk District Attorney should tell you something. To me, it lets me know he knows that this is maybe something he shouldn't say, that he has never said in any other case, but because this case is what it is, he has decided to either cross the line, get close to the line, not care where the line is, and make this statement when he has never done it in any case that he's prosecuted, that his office has prosecuted in the past.
The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
That's fine. Coming out and saying witnesses need to not be harassed, it's outrageous. We really should not harass witnesses. Now, he did say in the prosecution of Karen Reed, he did not say who is presumed innocent, which the rules very clearly say. Let me cite the paragraph. The rules very clearly say that if you're going to bring that up, you must also talk about the presumption of innocence. The fact that a defendant has been charged with a crime, unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. That's comment 5, paragraph 6. Okay, and we're going to do that so everybody can go back and reference that. I read through the whole thing. We are going to cite the rule if we have any issue with anything he says.
Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that his phone did not enter that home.
Okay.
11 people.
We're going to stop before he gets to the 11 people. So he talks about what is evidence? What does the evidence prove? He never went in that home. What does the phone data prove? Phone data could be considered testing. All of this is definitely considered evidence in the case. And again, comment 5, paragraph 3, the performance or results of any examination or test, or the refusal or failure of a person to submit to the test, or the identity or nature of physical evidence expected to be presented. That's basically his entire comment. Is the evidence and the testing and the results that's going to be presented that proves X, Y, or Z. Almost completely flying in the face of this Rule 3.6 for the rules of professional conduct in Massachusetts. This is what we call litigating the case in front of the media. Now, we have to think about, is he just responding to comments? And I would say, saying the harassment needs to stop, saying conspiracy theories are just that, theories, and just wait until you see what comes in at trial, all of that's okay to respond. This is going too far. This is taking it a step too far, which the rule specifically outlaws.
That this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
Okay, so hop back over to the rule, and this is comment 5, paragraph 1. The character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness. So the character and credibility of a witness and the identity of a witness, and he mentioned Colin Albert, he's going to name a bunch of other witnesses, or the expected testimony of a party or, you guessed it, witness. So he's talking about the character, credibility, identity, and testimony of expected witnesses. Literally things that are outlawed by example in comment 5, paragraph 1. Just to make sure somebody couldn't argue that this might not materially prejudice a proceeding. And if he wants to argue that he is responding to protect Colin Albert or protect any of the Alberts or the McCabe's, he does not have that right under this rule. You want to know why? Because the rule specifically states that a lawyer can respond to protect the prejudicial effect on their client who is a party to this litigation. Now, if he did represent Colin Albert and he came out and said this stuff, I'd have no beef with it. If he did represent the McCabe's or the Alberts and he came out and said it, I'd have no beef with it because these comments against these witnesses have been made publicly. So you can come out and you can respond if you represent those witnesses. But what you can't do is come out, litigate the case, talk about how your evidence is credible, their evidence is not. This is almost prototypical prosecutorial misconduct in the media, in my opinion. There's no room in the United States of America for this. This reminds me of the Making a Murderer case, if you remember the Stephen Avery documentary, where that prosecutor came out, said he's guilty, talked about all the evidence they have against him. This is trying to poison a jury pool. And what I would say is, yes, I think some of this can be said. Conspiracy theories, witness harassment, you can talk about those things in vague effect. Wait till you hear the evidence at trial. You'll see what's credible and what's not. All that stuff is fine to me, especially in response to what the defense has done and said in this case. But doing it this way is totally inappropriate, in my opinion. And to take it a step further, I almost feel like this has given free reign. It's almost like when you have a rebuttal close after the defense does their full closing. It's like, are you really going to say something's outside the scope of the defendant's close when they basically said their client's not guilty? You get to come up and respond and say why they are guilty. This to me seems like a comment and comments made to the media that give the defendants full range to come out and respond to all this stuff he's saying. To the testing of the phone, who said what, when Karen Reed's vehicle was there, where John was, how many witnesses there were, who was there when, what did they see, what do they know, what are they doing? Now I'm just responding to the prejudicial effect that Michael Morrissey has caused with his public statement as a lawyer who's on this case, investigating or supervising this case and litigating this case. How would almost anything the defense say not be a response to these comments? Let's keep listening.
Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case.
And again, he is giving out their identity, talking about the character and credibility and reputation of these witnesses and what they have to say. Now, he could say a lot of this is already public, that they're witnesses, the identity, and even what they're going to testify to, maybe that's all public. But he's not just restating anything. He's putting together an opening statement or a closing argument, depending on how you want to look at it, of why what they're saying is true, why anything against them is false, and why they have the right person in this case, which is totally inappropriate.
To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses.
And I'm trying to find things that I think are okay and appropriate. It's hard. But to say a witness being accused of this crime and a witness being harassed in a case is totally inappropriate. We don't want to silence witnesses. We want them to come forward and tell us their honest opinion. That's all okay. And that has some of the other public policy. It's necessary. We don't want the community to be in fear. We want them to come give us information if they have it. It fits under all of those subparagraphs of Rule 3.6. So all of that I think is okay, couched a certain way, not the way he did it.
Doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic.
Do you think the autopsy might be tests? Do you think he's going to tell us the results of that testing? Why in the world would he need to do that? There's just no way. There's just no way.
Is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
Literally, these are the questions before the jury. These are the questions before the jury to determine guilt or innocence, guilt or not guilt. And he's putting it out there as a matter of fact, no doubt about it. Here is the truth from the horse's mouth, and you should believe me because I'm the elected DA in Norfolk County. And here's the difference. I can get on YouTube and I can say, oh, that doesn't look like it's from a dog, or, oh, it doesn't look like it's from a car, or I don't think this, or I don't think that, or here's how experts are going to talk about this, or this expert's going to say that. I've had an expert that says X, Y, and Z. It's very different when the guy who's doing the investigating, the prosecuting, the litigating, putting people in jail in your community comes out and tells your community, these are the facts. We're not hearing any innocent until proven guilty, presumption of innocence, rights of a criminal defendant, rights of an accused, none of that. He is out here giving a closing argument. These are the facts, and there's only one way this case can ever go. And this is almost like a video that should be used in PR class and professional responsibility and ethics class in law school of why prosecutors can't do stuff like this. Because when you try to discuss and respond to facts, it turns into a closing argument, which is exactly what these rules are supposed to avoid. Now, people are going to, they hate Hank Brennan. If you think the defense is coming out and saying things that are prejudicial, you go and you ask the court for a gag order. And you give them the reasons and you say, Judge, look what they're doing. I either have to respond to the media, which I think would violate Rule 3.6 of professional responsibility, which is what happened here, in my opinion. There's no doubt this was a violation of Rule 3.6. So I either have to do that or we got to have a gag order. And again, I followed nothing before the first trial. Maybe they did try that. I don't know. But if you think the defense was saying things that were bad enough and prejudicial enough, the judge should step in and put a gag order on it. This is not what should happen. By the way, in case you don't notice, things coming from cops and prosecutors are taken differently than things coming from criminal defense lawyers, just to the public at large. Maybe that's changing a little bit, but in the history of the legal system, they don't exactly look as kindly on a criminal defense attorney as they do on a prosecutor fighting for justice. Harvey Dent.
A grand jury of everyday citizens. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence.
I guess he did say it. I forgot. He did say that she has the presumption of innocence. So I was completely wrong in the beginning when I said he didn't say it. But what I like how he said it, I don't actually like this, but how he says it is the presumption of innocence. She had it, went before a grand jury indicted her, as if a grand jury is the same thing as a jury trial. And he is purposely, in my opinion, trying to confuse a jury, I should say a potential jury. He's trying to confuse the public, basically, that maybe is not into true crime, that doesn't follow this stuff, that hears grand jury, and all they do is hear jury. And so they're like, oh, if a grand jury thought so, then she must be guilty. He is specifically using the things you are not supposed to use in the law to try and say a person is guilty before they are found guilty. Meaning they're arrested, doesn't mean they're guilty. They're prosecuted, doesn't mean they're guilty. They're charged. A grand jury indicts them. A judge finds probable cause. None of that means they are guilty and going to prison, which is obviously why Karen Read is still not in prison right now, even after all this. But he is very clearly using it to say the grand jury is basically smashing the presumption of innocence.
Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no...
I would agree with you. It's so funny the way he's talking about the witnesses, which I agree with wholeheartedly. Don't harass them. Don't convict them in the court of public opinion. I know people will disagree with me with that. That's fine. We shouldn't do that to witnesses. We should see what comes out in court, what evidence is actually admissible and true and real, not just what we hear or read online. But he should be saying the same thing about Karen Read. Don't harass Karen Read. Don't convict her yet. Let the jury do that in the court of law. Don't do that on the internet. Don't be saying she's guilty on the internet. He should be saying the same thing about her. If he just did this as a blanket, listen, witnesses, parties in the case, everybody calm down. Don't come out with your pitchforks. Don't convict people. Let's wait and see what happens in the court of law. Yes, there has been probable cause to arrest and charge this defendant, but yes, she is sitting there presumed innocent.
No rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy.
I agree with that. The internet doesn't know all the facts.
And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
So again, I don't disagree with the logic of that, but him saying that raises the credibility of EMTs, cops, prosecutors, firefighters, and those are a lot of the Commonwealth witnesses. And in jury selection, we specifically say, hey, juror number 3, do you think a cop taking the witness stand and John Smith taking the witness stand, just a bystander, would you give any more credence to the cop than you would to John Smith? And if they say yes, we say, well, you're not supposed to. And that can be struck for cause. Because a cop is a person just like John Smith is a person, and both of those testimonies should be weighed the same, and you should test their credibility. And if you don't find them credible, you should throw out the cop's testimony just like you should throw out John Smith's. But if you find them both credible and they're opposing opinions, you've got to figure out how to weigh that. You can't just say because he's a cop, he's right. But that's the type of background feeling we get, an inference I believe he wants us to get from some of these comments. All of these good people and public servants couldn't possibly conspire against one person. I agree that's hard to believe, and it seems like it's very out there in like the Twilight Zone. But just because they're cops and lawyers and EMTs doesn't mean they can't conspire, which is why he shouldn't come out and make this closing argument to the public. He's literally doing what he's condemning. Don't try this case in the media, try it in the court of law. And yet that's exactly what he's doing.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident.
But he was there other days. I'm not going to even try to argue factually with what he's saying, right? But again, he's coming saying, cop, Michael Proctor, great guy, great witness, didn't plant anything, couldn't have planted anything. He's trying to add credibility to his testimony. He's trying to tell us what he believes Proctor will testify to. All things specifically delineated and outlawed in Rule 3.6. Now, the response from Morrissey will be, I'm correcting the record. I'm coming out and protecting things and responding to prejudicial comments made. But guess what? Michael Proctor is not a party. Michael Proctor is not the client of Michael Morrissey. So I think he would be hard-pressed to actually see how this fits into the rule's exceptions and why, when you can come out and say something, this doesn't really fit. And the way that I read the rule, this is just one man's opinion. Just my opinion. I'm not stating it as fact. I think these comments are probably in violation of Rule 3.6.
Proctor,
at least arguably, right? And I don't know if the defense made that argument.
and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no...
So the as has been suggested is like, I'm responding to what's being said publicly, that Proctor planted evidence. He's going into way too much detail. That's why the rule says you only say as much as you need to, don't go any further. Let me see if I can find what it says. Here we go. And this is comment 7. Finally, extrajudicial statements that might otherwise raise a question under this rule may be permissible when they are made in response to statements made publicly by another party, another party's lawyer, or third persons, where a reasonable lawyer believes a public response is required in order to avoid prejudice to the lawyer's client. Now, I guess he could argue he represents the people of Massachusetts, the people of Norfolk County, and he needs to set the record straight to protect the prejudice against Norfolk County. Okay, maybe there's an argument there. When prejudicial statements have been publicly made by others, responsive statements may have the effect of lessening any resulting adverse impact on the adjudicative proceeding. But here we go. Such responsive statements should be limited to contain only such information as is necessary to mitigate undue prejudice created by the statements made by others. So do you think he's saying only what is necessary here?
Opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
So once again, he is stating as fact that Proctor wasn't close with anybody, had no conflict, had no beef with anybody. We can disagree with that, clearly, but you just shouldn't say stuff like that factually to the media when you are the sitting DA in a murder prosecution like this.
And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now.
Fair trial for who, right? I mean, he's talking about a fair trial for the Norfolk DA's office.
And the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. but the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
He even says right at the end, let's play it one more time, why he's doing this as a quoted statement that he wrote down and thought about versus a press conference.
Using this quoted statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court.
So he knows that he can't do a press conference. It might go off the rails. People might start asking him questions. He might start, giving more information than he can because he knows that it has to be so narrowly tailored as to only say what is necessary to mitigate the adverse effect of any comments made publicly. So why did you bring up the grand jury? Why did you bring up Proctor's motives? Why did you bring up the fact that all of these witnesses are consistent and say the same thing? Why did you bring up the autopsy report and what it says and what it shows? Why did you bring up what John O'Keefe's phone was saying? Because that's the point of the trial, right? Is there's facts on both sides, there's experts on both sides, everybody's going to make the arguments, and the jury makes the decision. So to come out and say these things as fact flies directly in the face of what this rule is trying to protect. And the way you mitigate it is to say, these are all conspiracy theories. You'll hear the truth when it comes out in court. There's a reason none of these witnesses have been prosecuted. They've done nothing wrong. Just generally speaking, not naming each witness individually, saying what they're going to testify to. That's the way I read it. Maybe I'm too strict. Maybe I'm too much of a stickler for the rules, and I try to avoid prejudice if I was a prosecutor. Because if you have a good case, this stuff doesn't matter. The defense can blow smoke in the media, and when you show up, we've seen it before. And you show up in trial, and the prosecutor's got a locked and loaded case, and they win. Even sometimes when they don't have a locked and loaded case, they win. So to come out and do this to me is nothing but to poison the jury pool. Thank you guys for sending me this. I hate to see stuff like this. I really do. I mean, this is horrible. This makes you look so invested in the outcome, not just for justice, but for protecting your reputation, the reputation of the cops and the witnesses in the case. That's what it felt like to me. So I don't love it. Don't love to see it. I hate to see it. And if I was a judge, I would not be looking on this kindly. And I probably would have a problem with some of the things the defense said pre-trial, which I haven't watched all of their statements either. But I think asking for a gag order would have been better than coming out and making this comment. But let me know what you guys think. I'm sure you will in the comment section. Thanks for hanging out with me today. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.